prorated share of the taxes, and the seller is going to be credited that amount that the buyer paid because the seller paid for the whole installment. So the sellers should get back the amount that they paid from close of escrow to the end of the installment period. So again, I just thought that might be helpful if you just had that kind of just printed out as a roadmap, so to speak, as to how it's going to be handled. Okay, we've got more copies of this coming, and if you have other questions about this, let me know. We won't need to refer to this again until we get to the end and we talk about hiring your children specifically as a model for in your advertising. Okay. Any questions from Monday? I was going to say last week. Seems like it was a week ago. From Monday. Does everybody have a handout? There's a few of you that look like you weren't here. There's handouts up here. Is there two of you back there? Three of you? So a couple of quick things I want to, somebody else need one? I've got more of the, everyone good? You good? Okay. Whenever I teach it, there's so much information. There's, the next day or the next morning, I think, oh, I should have mentioned this, should have mentioned that, should have clarified this, and so forth. So, you have the handout that has a copy of the tax bills. I just wanted to share. You have the handout that has the tax bills, the outline. This part, yeah. Go to my tax bill. I just wanted the one on Overactor. But I wanted to give you an example of when we talk about the value being increased a maximum of 2% annually, what does that look like over time? Okay, I purchased this property in 1996 for $445,000. And you can see where the value today, with not every year's been 2%. There's probably been 5 or 6 years when it wasn't 2. But I mean, what's the value now? 7 something? So that's the benefit of Prop 13. My home probably conservatively is worth about $2.5 million for its land value, because I have almost an acre of land. It's worth probably 3.5 to probably, by the time I sell it, it'll probably be worth close to $4 million for its land value. But you can see just the benefit of Prop 13. See, in many states in California, tax based on fair market value. So just imagine, without Prop 13, I'd be paying taxes on probably at least $2.5 million when it's only 7 something. So again, I just wanted to point that out just as an example of the benefit of the Prop 13 2% cap on the increase in assessment. A lot of you came up after the class and you looked up your property to see whether you had the homeowner's exemption. Some of you did, some of you didn't. You can file for it at any time. If you file for it by February 15th, you get a full $7,000 exemption for the year. If you wait till after February 15th, they prorate it. If you file between February 16th and December 10th, you'll get a prorated exemption. That $7,000 will be prorated based on the number of days in the year. Each year thereafter, you'll be at $7,000. All right? We were talking about using entities to avoid reassessment under Prop 19. So I want to clarify with respect to trusts. Soon after Prop 19 was passed, a lot of attorneys were saying, yeah, there's special trusts you can use to avoid reassessment for parent-to-child transfers of non-principal residence property under Prop 19. It's not that simple, so you want to definitely consult with an attorney before you even consider the trust as the entity to try to avoid reassessment of property that's not principal residence. The corporation or the family LLC is still the preferred method. But you need to understand there are what are called, there's specific legal entity change in ownership rules, and it has to do with percentages of ownership. So it's not complicated, but you've got to make sure you're dealing with an attorney that understands how these LLCs work and how to structure it so that you accomplish your goal. The other thing I want to make sure we're clear is that if your parents that you own the property solely and you want to set up this LLC or corporation to avoid reassessment later, the initial transfer has to be from you as parents to you as parents as shareholders of your corporation or members of the LLC. Your children don't come into the picture until after you've already created the entities, because they're not owners of the property when you make the transfer. So it makes sense? So you just want to make sure it's a two-step process when you do that. I kind of sense from some of the questions that some of you maybe were thinking you should transfer your principal residence to an LLC. Not a good idea. There's all kinds of issues for not wanting to do that. You can run into these entity change in ownership rule problems. It could preclude you from even being able to use the exclusion for principal residence. You could lose the homeowner's exemption. You're going to have difficulty deducting mortgage interest because it's no longer a personal home. It's going to be difficult to finance the property, and you're going to have insurance coverage issues. Bottom line is your principal residence is what we call a low-risk asset. The likelihood of somebody, yes, a guest could sue you if they tripped on your patio or sidewalk. Yes, that could happen. But that's a much lower risk, and that's what we have insurance for, okay? The most important thing you can do on an insurance standpoint is make sure you've got sufficient insurance coverage. And if you own more than one property, you're likely going to have an umbrella policy. Your homeowner's policy may only go to 300, 500, maybe $1 million, but you can get an umbrella policy which will take you up to $2 million, $3 million, as high as you want to go. And you make that higher and higher depending on how many properties you have. But again, you've got insurance is different. When you've got LLCs, you've got different insurance policies. So I just want to make sure I kind of sense some of you thought maybe I should put my house in it. No, it's not a good, there's too many issues with that. We're talking about your rental property, investment property that are tenant occupied. So that's where you have more exposure. And even more so if you've got a rental property with a swimming pool. Okay? Yeah.
So when is it recommended then?
Yeah.
Like,
When is,
you said it has a lot of issues, right? So it is only recommended.
I wouldn't, just don't consider putting your principal residence in an LLC. You're going to have a host of issues that you don't want to have to deal with. It's a low-risk asset. Just make sure you have adequate insurance coverage.
So when it is advisable to have LLC?
When you have investment properties, rental properties, and you want, and it's really, we're talking about high net worth people that have a lot of assets that could be pursued by way of a judgment if you're sued, and could be sued for well above your insurance coverage. So you need to understand, folks, insurance only pays out up to the policy limit. Someone could get a judgment for you for well over your policy limits. You ever read about people getting these huge? Look at all the attorney commercials and all these judgments they're getting. Okay, Sweet James. I mean, the guy's all over the place. 25, huge. Those judgments are well in excess of whatever insurance. If it was an individual, they didn't have insurance that high. See, so that's your exposure. Your exposure is to potential claims in excess of your policy limits. That's why having an umbrella policy, see, an umbrella will cover both your home and your auto. Okay? As long as you have, there's certain minimum limits under auto and home ownership, that qualifies you for an umbrella policy. Premiums aren't that high. We're talking in the hundreds of dollars, not thousands of dollars, to add another umbrella on top.
So, if I have a principal resident and I know that I'm gonna die by cancer, right, I mean, something like that. So at that point of time, it's advisable because.
Should be in a trust,
should be-
not in an LLC, no. LLCs, it's for it's meant for investment property. They're higher risk assets, more likely of lawsuit arising out of it, okay?
So what is the best way to protect your residential property,
Protect it from what?
all these lawsuits?
You can't
Insurance.
protect it.
Okay, trust,
You can't protect it,
even trust cannot protect it?
no. You are considered the owner of the property.
Okay.
When you are a trustee of a trust, you have all incidents of ownership. It's as if it's still in your name. It doesn't change anything. There are tax benefits to having trusts, but a trust it's not a separate entity, separate from you. You and your husband, if you're trustees of your trust, you are considered the owners.
Oh,
Okay? There's no liability protection from having a trust.
So basically, you're having a trust for the primary residence.
Mainly you're having a trust to avoid going through probate when you pass away.
Steve,
Okay.
our team, recently had a listing where there was a trust, but the house was not in it.
Yeah, they failed. Oh, yeah, I've had that.
The trustee was deceased. It was a mess.
Yeah, and then you gotta go through probate. I had one where the mom
So why
set up a trust.
what's the benefit of doing that?
The trust is to avoid probate, so you don't have to hire an attorney and go through probate and spend 6 months plus paying an attorney to probate the estate.
If
See, a
you've got
trust.
a will,
Yeah,
it's gonna go through probate.
yeah,
If you got a trust, it won't.
Won't
and
go
it'll
through
save
probate.
you time and money.
yeah. It's all a probate avoidance tool. It's very simple. A trustee can act, as soon as a trustee has the last owner, the last trustee can, with a death certificate in hand, now has power to handle all the trust assets. No attorney involvement, no court involvement. Yeah, I mean, I can tell you all kinds of stories. Mom gets a trust and they only put half the house in the trust. So it's like, so much for probate avoidance. You still had to go to probate because the other half wasn't in the trust.
I have a question. So even if you have a will, the property goes through probate?
If you die under 3 situations. You die with a trust, you die with a will, or you die without either one.
Right.
If you die without either one, or you die with a will, you go through probate. If you have a trust, you don't go through probate. Okay? You're still going to have a will in your estate plan. It's what we call a pour-over will. And the purpose of that will is if you have property you acquire after setting up the trust, it will put that property into the trust, but you still have to go to the probate court and file a motion to get an order saying, yeah, that property belongs in the trust. But it's a shorter, less expensive process to do that.
And the advantages of the trust go beyond just your homeowner.
Yeah, yeah. Remember, you have a will, you still have a will, because if you have minor children, you've got to appoint a guardian in the will. So if something happens to you while they're a minor, that's what the will is. There's still a purpose for the will if you pass away with minor children. But the passage of your property, and we're talking your property, your IRAs, your stocks, your bank accounts. You can have your trust can be a beneficiary on your life insurance. See, I have everything goes to my trust, so that at the end the trustee will manage all the property under the trust. Don't have to deal with all the other companies because they all know everything goes to the trust and the trustee has the power over all of the assets. I'm currently serving as a trustee for the 4th time. Okay, and it can be a pain if all the paperwork and everything hasn't been done properly up front. Ends up with a lot of time and effort. Now, as a trustee, you can get paid just like an executor on will would get paid. You do get paid, but most times in a family situation, parent to child, typically the child doesn't pay themselves. They might if they've got siblings and, you know, they want to make sure they get they're getting paid for their time. That's up to them. Only children, you know, you're not going to pay yourself because it's all yours anyway. Make sense? Any questions? Kind of got off a little rabbit hole there. What's that?
How you get paid? Like if you.
You keep track of your hours. I've been, what is it? I've been a trustee on my in-laws trust for 5 years now. And I keep a timesheet of all my time, tenths of an hour, just like when I was an attorney, tenths of an hour. Keep track, keep a timesheet, and at the end of the year, I write a check to myself for the whole time I spent that year. If you're not an attorney like me, typical hourly rate for a family trust would be $25 an hour. And the trust says that you're entitled to that. On the probate side, there are fee schedules. Probate has fee schedules for both the attorney and the executor based on the value of the estate. You're not going to have an attorney charging $500 an hour for there's a set schedule by statute based on the value of the estate as to how much the attorney gets paid and how much the executor gets paid. All right, moving on. We got a lot to cover here. One other last thing I didn't mention, there is a grandparent to grandchild exclusion. We talk about parent to child. There is a grandparent to grandchild exclusion. It only applies, again, just like parent to child, it's got to be grandparent's principal residence to grandchild used as principal residence. Both parents have to be deceased. Okay? You can't just skip the parents. They have to be deceased for that to work. Okay, federal capital gains. This is obviously a big issue because most of our sellers, may or may, depending on how long they own the property, may very well incur tax liability on the sale of the property. And for a lot of people, it's a good idea to have some sense of what that liability may be. The tax rates are based on your taxable income. The most common for most people is the 15% rate. That's for married filing jointly if they have taxable income between $96,701 and $600,000. So a lot of your clients are going to fit into that 15% bracket. If they have taxable income married over $600,050, they're in the 20% federal capital gains bracket. Okay? Now, those rates apply to property that's what we call a long-term capital gain, meaning it's been held for more than a year. If it's 1 year or less, it's what we call short-term capital gain. It's taxed as ordinary income. You hear, somebody's in the 28% tax bracket, or say 24% tax bracket. If they have a short-term capital gain, they're going to pay 24%. If they're higher, it's a higher bracket, they're going to pay more. And if the top bracket's 37%. So as you see, when you own a property for a year or less, you pay a lot more in taxes than if it's long-term. So there's one question for, right there. Yeah, that's it. That's a question for someone. One of the things you got to do, whenever you get a prospective listing, the first thing you do is pull up the tax record. Who are the sellers? Am I talking to the sellers? Are they alive? And when did they buy the property? Because if it's been less than a year, but it's getting close to a year, depending upon someone that's owned it for less than a year, probably not going to have any gain because there's going to be an exclusion. They're married, they're going to be able to exclude up to $500. Now, if they haven't lived in it for 2 years, though, then you got to look at why are they selling. We'll get to that in a minute, because there could be a reduced exclusion. Typically, where you got to is the flippers are the ones that are subjecting themselves to the short-term gain because the ordinary income, because they're flipping them in months, so they're not owning them in most cases. more than a year. So they're not getting the benefit of the low capital gains rate. They're paying higher rates, but they're having typically shorter ownership periods. So they still make money, you know, in the long run. The bottom, additional tax, net investment income tax, that's referring to the Obamacare tax. When the Affordable Care Act was passed, yes.
So you said that short period owning and selling, there's an advantage. for
Well,
people.
they're only, well, because they're paying an ordinary income tax rate, but it's a short, you know, it's just gonna be on the amount of income, you know, at that rate.
Okay.
I mean, it's gonna be whatever the rate is. It doesn't, the length of time doesn't really matter. Yeah. So Obamacare is another 3 point, I was gonna say was when as part of the funding for the insurance with the Obamacare, the Affordable Care Act, they added this 3.8% tax, and they pushed it by saying that it was going to only affect the wealthy. Well, guess what? It affects a lot of people because it kicks in, depending on your modified adjusted gross income, you know, it'll kick in at either 200,000 for over 200 for single or 250 for someone that's married filing jointly. I'll show you, I don't want to get into the weeds with each one of these. I'm going to show you an overall calculation of what the taxes look like in a minute. Now, to figure the gain, the first thing you have to do is you have to determine the seller's basis in the property. Basis starts out as what was the cost of the property? What did they pay for it? Well, that starts out as purchase price. That's their cost. But there are adjustments to the basis. And the adjustments to the basis appear in their settlement statement. They appear in two statements. Actually, the adjustments to their basis is going to appear in their buyer statement when they bought the property. All their one-time expenses, other than expenses relative to taxes, insurance, and financing. You take out everything that deals with financing, loan fees, and you take out dealing with any property tax expense, insurance expense. Those other one-time costs get added to the price. So it's the cost of purchase. So you get to bump up that purchase price by a little bit more money. Okay? You've got this in your handout. So you've got your title and escrow fees are your big ones. Okay? Those will get added. So what you need to explain to your particular first-time buyer is, and now everybody gets soft copies of everything, so they should be able to hold on to these documents. They need to make sure that they keep this settlement statement available in their tax records, because when they sell the property, they're going to have to first determine their basis. And the first step is, what were my costs, my one-time cost of sale when I bought the house? And then the next step is going to be, what capital improvements have they done to the house during ownership? So this is a list of what the IRS recognizes as capital improvements. Pretty self-explanatory. Capital improvements are not repairs. You got a plumbing leak, you fix the leak. That's a repair. That's not a capital improvement. That doesn't add value to the property. It just restores it to the condition it should be in. Okay? So that means you need to keep receipts of all the improvements that you make. Or at a minimum, at least, and we don't have, I'm talking like an old guy, we don't have many canceled checks anymore, okay? This can be real problematic for people. I had clients who had bought and sold about 4 times and didn't keep a thing, had no paperwork whatsoever, and I always wondered, what did they ultimately do when they had to file the last tax return? How did they, the last house they owned for years and years, how did they even determine what their basis was in the property? They had no records whatsoever.
But a custom should have the record, right?
Personal tax return, no, it's not gonna show what you spend on capital improvements. You don't deduct capital improvements on a personal return. An investment property will show what was spent on the investment property. We're talking about principal residence. I have a full box that's almost full, partially because I did a major remodel that, you know, had a stack of receipts like that, but I just have a box that I keep filling that box up, and it just gets fuller and fuller of receipts when the time comes for me to have to figure out how much did I put into this house over 30 plus years. So this is an important one. My sister-in-law, they moved to Arizona, and she said, we want to sell. They had a house in Fremont, and the son was living in it. Well, the son was going to move to Arizona. She said, sell the house. Okay, sell the house, and getting ready, you know, getting close to the closing, and I don't know, the issue of taxes came up, and they hadn't lived in it. They'd been gone over 2 years, so they weren't going to get, you know, the exclusion. They'd wait over 3 years. They'd done been in it for over 3 years. She had just, about a month before she called me about selling the house, she had just tossed a bunch of years of paperwork, including all the receipts for the house. Now, what I tell people is just try to sit down at your computer and just write a list of everything that you recall doing to your house and how much you recall paying for it, and just make up a list to the best of your memory. Now, you know, if you wrote with checks or credit cards, depending on how far back, you may have access to credit card charges. You may have access, you know, banks keep check records back so far. You may be able to figure out the amounts through through online checking, credit card accounts. You know, try to get the numbers. But if you can't, if you don't have records, you know, that far back, you just have to kind of go from memory, and then just tell your tax preparer, hey, this is all I could come up with. I don't have anything to back up. 9 times out of 10, you know, because the audit risk is fairly low, they're going to say, well, we're just going to take it, and then just, yeah, if you do get audited, then we'll deal with it when the time comes. But it's likely that you may not get audited, so you just make your best effort, rather than not use anything at all. Yeah.
So a couple of questions. One was on the estimated statements. I see that the property was in San Jose, but I don't see any city transfer taxes. Is there any specific reason? Because San Jose does have city transfer taxes.
This property was outside the city limits.
Okay.
This was up in Sierra Road, and it was county.
Oh. So if it's, okay, unincorporated.
Yeah,
So that was one
unincorporated,
question,
yeah.
That answered. And then as it pertains to these improvements, the costs that you put in, I suppose there is no inflation adjustment or anything, it's.
No, it's just,
whatever
no,
you've
it's
done.
your actual expenditures, yeah.
Okay.
Just your actual expenditures over time. One interesting one is you can only do carpeting or flooring once. You can't keep repeating on the, yeah, they got a special rule for that on flooring. So again, on the buyer, so you want to make sure your sellers hold on to the buyer statement when, you know, or they have the buyer statement. If you're meeting them as a seller, you want to say, do you have your statement from when you bought the property? Okay. They may not have it. I mean, they're not missing out on. It's not, you know, it's gonna, you know, it's gonna be owner's insurance type, you know, escrow. It's gonna be a few $1,000s. It's not gonna be a huge amount. But, you know, but if you're having to pay taxes, every little bit counts, you know. Now, this is your seller statement. This is the first one you have. I just put sellers first. So this is what they're gonna get after close, and they're gonna need this one because this is all going to reduce the price of the property. All the costs of sale come off of the purchase price to determine your capital gain. And this is one you'll get, I get maybe one out, at tax time, 1 out of 5 of my sellers will call me. They can't find it online. They've got this appointment, and they go, well, where's the paperwork? I don't know. Let me call Steve. And say, Steve, can you get this? Yeah, I'll get it for you. I mean, I've kept every settlement statement for every transaction I've done over the last 35 plus years. And I occasionally have to go pull a box out and get one for somebody because they didn't keep it. That's why even when I purge files, I save the settlement statements for everyone, because I'm talking, pre-online days, okay? But even today, I still just hold on to, I have a box with them. The other thing you want to keep is if you ever do a seller carry, keep those records, because the seller, you give them everything, but they don't save the note, they don't know that, they don't have an amortization schedule, and so I've had to pull those out from time to time as well. Just as an aside, again, not as important now because everything is soft and saved online, but many of us for years and years have made it a practice. After every closing, we make a copy of the settlement statement. We have a cover letter addressed to the seller. We print that, we put it in an envelope addressed to the seller, and we file it away. And on January 31st, we mail those out to all our sellers. And basically it says, we know tax time is coming up, and this is an important document that you're going to need for your tax preparer, and here it is, so you can add it to your paperwork when you go, and then they don't have to fool around looking for it and find it online and all of that. That's a great touch. Okay? Everyone understand what I just said? Yeah, it's a great touch to touch them. Lets them know you're thinking about them. You know tax time's coming up, and it just makes it easier for them to have that document ready. So again, this is a settlement status of property I sold in San Jose. This is both ends, buyer and seller. So all the costs on this statement are cost of sale, which will reduce the price. Everything except the taxes and the loan payoff and the loan charges. The transfer tax is okay because that's a one-time, but your recurring property taxes are not a cost of sale, and all your fees relative to the loan and paying off the loan are not. So you add up everything else, and that reduces the price. I don't know, what does it come up to about? The loan was $470. Yeah, so you've got, we had to call it $647, and the loan was $470. Yeah, so the seller had $177,000 in cost of sale, because he paid me $168,000. Okay? So we sold the property for $2.8. This house the open house for this house was a zoo. Had this parking lot that could hold about, parking lot probably handle about 12 to 15 cars, and people were all coming up and parking, and then people wanted to leave and they had to wait for cars to move. It was like, I should have had someone out there directing traffic. In any event, so you got $2.8 million purchase price. So he's got $2,623,000 is what we call the adjusted sales price. So then it's just a matter of what was his basis. I don't even remember what he paid for the property. I think, I want to say he paid like about $600 or $700 for the property sometime. It was on 5 acres. But let's just say now his wife passed away. So there's a stepped up basis there. So there's 2 ways to calculate stepped up basis. One is you look at title. If the husband and wife own title as joint tenants, half of the property gets stepped up. So let's say the property, I listed the property for like 2.5, that's what the comp suggested, but the market was so crazy it ended up going for 2.8. I had about, I don't remember how many offers we had. About 5 offers. Let's just say, what did I say, he was at 2.623. And let's say it was I need a better marker. Let's say it was 2.2 million. See if this marker is better. If they held it, okay. Each spouse gets has half the basis attributed to them. Let's say that on when the wife passed away, the value of the property was $2,200,000. So we say stepped up basis, you step it up to value at date of death. They could have bought the house for $600,000, but when one spouse, in this case, the wife passed away, so it was husband alone. So he gets a stepped up basis to value at date of death, but to determine whether he gets half of it or all of it is based on how they held title to the property. If they held title to the property as joint tenants, only half of it gets stepped up. Okay? If they held title as community property, both halves get stepped up. And and most, for years and years and years, the common form of ownership for a married couple is joint tenants. Now, if you go do a trust, the trust by its terms is going to make all property, however it was held, including joint tenancy property, it's going to make it community property. So you get the stepped up basis of both halves. But I've had situations where there was no trust. Go back, joint tenancy, because that was how everyone took title. And so the widow or widower only gets the benefit of a step up to half. See, I'm pretty sure Fred had a trust. So that means he would have got a stepped up basis. So if it was worth 2.2 when the wife passed, and I'm not even getting into his capital improvements, because his capital improvements might be irrelevant because of the stepped up basis. My point is, let's say they paid $600 for the house and put $400 into it over the life of the house, that's $1 million. That's going to that's irrelevant because we're going to step it up here. Now, if she was still alive, then the $1 million would be their basis. Okay? Are you following me here? So wife's passed, so basis is 2.2. So the gain is $423,000. Now, you've heard of the capital gains exclusion: $250,000 for single, $500,000 for married. As long as you've lived in the home 24 out of the last 60 months. And those 24 months do not have to be consecutive. You can move out, move back in. Most people it's consecutive. So you look back 60 months from close of escrow. Did they live in it as principal residence 24 out of those 60 months? Single, they're gonna be able to exclude the first 250 of gain. Married, be able to exclude the first 500. Now, I don't remember the exact timing here. The surviving spouse has up to 2 years from spouse's death to take the 500. Okay? Basically, it's, I say up to 2 years. It's the year of death and another year. Okay? So if I can't remember now how long it had been. In either case, with 500 with 500 exclusion, he'd have no gain. If he had to take it as a single, then he's looking at 173,000 in gain, because he's gets to exclude 250. Okay?
I have a
Yeah.
question. So if wife would be alive, then the base will be million. That's what
Yeah, in my example, the base is $1 million, so the gain would be, in that case there,
Around million.
$1,623,000. If the price, after cost of sale of 263, less $1 million, we're at $1,623,000. Married couple,
500,000.
yeah, take 500,000. Now you're at $1,123,000.
Wow. And what will be the percentage of the tax on that?
Okay, I've got a calculation in there based
Okay.
on a $2 million property with some different numbers. There, you're basically looking at about probably around almost about 34%.
That's a lot.
About a third of that.
Oh, okay.
Say, just call it, well, if you call it $1.2 million, about 400,000.
Wow.
Now, I'm gonna show you an example where it's like 800 and something thousand.
So Steve, in this
Because
example,
the low, the basis is low in the example.
where we were talking about the stepped-up basis for the surviving spouse.
Right.
Is that only applicable for primary residences?
No,
or-
stepped-up basis applies to all
property.
all capital assets.
So even investment property?
Stocks, everything gets stepped up.
I did not know that. I mean, I used to always think about kids, but
Everything gets stepped up.
that's pretty powerful.
Like I told you about,
Not that I want the spouse too.
I met Amazon employee number 5. You know, 50,000 shares
Wow.
of stock at $262 a share. $11,300,000 in Amazon stock. And I know he's got other stock too. And one of my buddies said, I don't know if I'd be holding on to it, he's taking a risk. I said, he's not gonna sell that stock, he's gonna leave that to his kids. Kids will inherit that stock and get a stepped up basis of value date of death and then turn around and sell it. All that capital gains disappears.
But it doesn't need to be kids, so if he goes, his wife will.
Well, yeah, well, both of them, they're gonna both hold, yeah.
Right.
Neither one of them will sell it. The kids will get it.
But she can, if he goes, then the wife
If
can
they
sell
held it
it
as community property, yeah.
or trust.
Or if it's in a trust, yeah. If they held it right, yeah.
So Steve, going back to your box of receipts, right, so you have 30 years of receipts. You sold this for 2.2, are you taking those receipts off the top of the
No,
price?
all those receipts go to the basis. To the, what did I have for a basis here? Well, I stepped up the base. If saving all the receipts is valuable if you're gonna sell it while you're alive.
Yeah.
If you're never gonna sell it, then it really doesn't matter.
Or if one
'cause-
spouse passes away, would.
Yeah.
then-
Yeah, it's still, one spouse passes away, it gets stepped up 100%, all those receipts are meaningless at that point.
Okay.
It's when you're selling, both of you are selling while you're alive, that's where you need the receipts. I hope I'm around to sell my house.
But,
I know my wife will be, she's younger than I am, but I hope I'm around.
Now,
Yeah.
is there a time frame after the passing
2 years.
that, the 2 years out of the last 5 years, is that to get that?
Now, after, you get the surviving spouse can use can take the 500, basically, just if they sell within, it used to be if you sold within if you had to sell, initially you had to sell it in the year of death, and then because that's not fair, because what if the husband passed away on December 31st? You don't have any time to sell. So they gave you another year, but now it's up to 2 years. So then excuse me, I've had that come up a few times, where we met that threshold to take the 500. Once that passes, then that 500 becomes 250. And then once they've moved out of the house and more than 3 years have passed, then there's no more exclusion. Now, a spouse could move back into a house. Let's say you had my closing yesterday, they lived here, they moved to Hawaii, they rented the house out for over 10, 12 years. But the husband passed away, so she ended up getting a stepped up basis to $1.65 million. I sold the because it was 2022. Sold the property for $1.6 million. 2022 was a hot market. But she could, if she was going to have a big capital gain, she could have come back here and lived in it for 2 years to qualify for the 250 exclusion, if that made sense. Now, the other thing I was going to share with you was I was telling you about adjusting the withholding. Now I'm dealing with the CPA, because they were going to 3% of $1.6 million was $53,000 and change. When I gave the CPA, the stepped up basis, the basis number, that $53,000 became $12,000. So instead of them taking $53,000 and sending it to Sacramento, they only took the estimated tax liability, which was about $12,000. And I told her that on the phone last night. I said, I just want to let you know what I got done here at the end was I got that 53 dropped to 12. So you pocketed another $41,000. Otherwise, the Sacramento Franchise Tax Board would have been just holding it interest free till April, whenever she filed a tax return.
I have one quick question.
Yeah.
So assuming that my spouse dies and I need to do the step up process, so the process involves.
Okay, here's how you handle stepped up basis. There's 2 ways to handle it. Shortly after the death, if you want to get your affairs in order immediately, whether you're going to sell right away or not, you got 2 choices. Is hire an appraiser to appraise the property. It's an estate appraisal. Or you can, if you have now you can't do it for your own property, but if you have a real estate broker, you say, hey, can you give me a BPO letter as to your opinion of the value of the property on the date that my spouse passed away. I've been doing them for years, and I haven't had one CPA or tax preparer refuse to accept my letter. The only CPA who won't accept my letter is my personal CPA. His position is he says the IRS requires an appraisal report. I said, all right, I won't argue with you. But he won't accept the letter. But I've done tons of them over the years, and they've always been accepted. Now, as the listing agent, theoretically you shouldn't be doing it. But typically it's like you're going back in time. It has no bearing on what you're doing today with respect to property. But here's the other thing. If you get someone who just wants an appraisal report, they just feel more comfortable doing that, here's the little trick. If you represent the seller and they need a estate appraisal, and the buyer's going to get a loan, the appraiser calls you to set up an appraisal and say, hey, I need you to do me a favor. Can you do an estate appraisal for me? Date of death is such and such date. And they'll go, sure. And I go, how much are you going to charge? Because remember, they don't have to make another visit to the property. They're already there. All they have to do is go back and do a market analysis 3 to 6 months prior to the date of death. They've already, and then you just have to describe for them what the condition of the property was when the spouse passed away versus today. So typically, it's like, I say, well, the property was in the same condition, except this is all the stuff we did to improve it. So back all that off, and then that tells you what the value was then. I typically get those done for about $350. So just make a note of that whenever that comes up. But again, every time I'm in this situation, I tell my seller, go ask your CPA or tax preparer, or give me their number, so I can find out, are they okay with a BPO letter, or do they want an appraisal? And then whichever one works, that's what you do.
What is PPO? Sorry.
Broker price opinion. Very short letter, just about 3 lines. Most of the time, I don't even give them the comps or anything.
You
I just,
cannot-
what's that?
So you cannot get BPO for your own, right?
No, conflict of interest, yeah.
Conflict.
Yeah, you can't tell the IRS, so yeah, this is what I think my house was worth. No, they want an independent opinion of the value of your property. Okay, you have, we gotta move on here. The other thing here is, I don't know how many of you are doing net sheets for sellers. I mean, this has all the information that goes, if you go to do an estimated seller proceeds, the CIR form, all the information you need, shows up here. And even on like the tax prorations, when you put in the amount of seller's taxes, once you tell it how many days from the installment period to charge the seller, it's going to automatically calculate the numbers for you, but you need the basic numbers to plug in. Same on the buyer's side. Now you can have an escrow officer prepare an estimated settlement statement for you too as well, but he or she may not have all the information they need for it to be a really accurate statement. So it just depends on why you're doing it and for what purpose. Improvements. So now the other thing you have what's called is a reduced maximum exclusion. That's a situation where you have a seller who needs to sell before 24 months. And basically that occurs in 3 primary things. It has to do with a change in place of employment, health reasons, or unforeseen circumstances. Unforeseen circumstances can be death, divorce, pregnancy, things like that. So basically you look at, and for place of employment, your new place of employment has to be further than, at least 50 miles farther than the old residence to employment. Can't go take a new job around the corner. That one, job relocation is the most common one. Comes up a lot. Where all of a sudden, they bought the house and a year later they go, oh, I'm being relocated, going to Texas, gotta sell. Okay, how many months do you own the house? 12 months out of 24, that's 50%. Married couple, instead of a 500 exclusion, it's 250. You get reduced 50% prorated by the number of months you own the house. Okay, and that comes up from time to time. The other thing to keep in mind, and now we're segueing away from principal residence for a minute, just to talk about a couple other things relative to capital gains, and that is investment property. Typically, investors are going to take depreciation on residential property. It's a straight line depreciation over 27.5 years. However, when you sell the property, you recapture that depreciation, and that's considered gain. So it basically reduces your basis and creates more gain in the calculation. But it's taxed at a different rate. It's taxed up to 25% rather than the normal federal capital gain rates. But you always want to make sure if you're trying to estimate how much an investor is going to have pay in capital gains tax, you can't do it because you're not going to know their depreciation recapture. But you need to remind them of it, because that's like a huge gotcha. But they're not expecting it to occur. Capital loss deduction. You can deduct losses on capital assets, stocks, bonds, but not on your principal residence. There's no loss deduction on principal residence. Now, the way loss deductions work is you've got to offset your gains against losses first. So you got your short-term gain, short-term loss. You determine is there a gain or loss there. You do the same thing with long-term. And then after you've done that, if there's any loss after that, you deduct that loss carries over, and you deduct it $3,000 a year until you've used it up. Now, here's the thing: if you've got someone who's selling investment property, doesn't want to do a 1031 exchange, and maybe selling it at a loss, you need to ask them, do you have any highly appreciated assets that you want to sell for a gain to offset this loss, to get 100% of the loss now? So, and I've had that come up. I said, yeah, based on my estimates, you're gonna have about a $50,000 loss. But I don't know about the depreciation recapture. But if they didn't depreciate, if it's that number, so well, if you go have some highly appreciated stock, you sell stock with up to a 50,000 gain, you'll wash out that loss, and you got to get the full benefit of that loss because it zeroes itself out. Understood? Because otherwise, you're taking losses at $3,000 a year each year. I mean, I have two beneficiaries of a trust that are going to be doing that. They inherited a house, and the way it all works out, based on the cost of sale versus it hadn't been that long since Dad passed away, and based on cost of sale, they're each going to have a paper loss, and they'll just be taking $3,000 a year write-offs, with loss write-offs on their tax returns. Income tax rates. I basically talk about this from a standpoint of the tax deductions for mortgage interest and property taxes. So this just gives you an idea of typically in California, this is California, I think? This is California income tax rates. The reason I've got this here is because California, I jumped ahead, California does not have a federal capital gains tax. California taxes capital gains as ordinary income. So you have your normal income, and then whatever you have and California pretty much follows federal law. I won't say 100%, but fairly close. Most of the write-offs and deductions and adjustments are the same. There are a few that are changed a little bit. I won't go into that. That's way in the weeds. But for the most part, California's going to follow federal law. So whatever your capital gain is on the federal side, that's going to be ordinary income on the state side. So then you look at what tax bracket are they in. Because what can happen is, let's say you got someone who's currently in a lot of people are in the 9.3, which in married is from 141,000 to 721,000. A lot of people are in that 9.3, married 9.3. But if you all of a sudden sell a house for a big gain, that could jump you into 10.3, 11.3, or even 12.3. Jump your bracket up, okay? Because that's more ordinary income from the sale of the house. This is another way to look at Obamacare if you're into wanting to see examples. It has to do, you have to take your adjusted gross income, then you have to do some calculations to come up with a new adjusted gross income and then determine what it is. I don't need to. So here's AI is great. Okay, AI made preparing for this class so much easier because I could just give it, instead of me having to do it manually, I could say, here's what I want, and it gave it to me. Assume taxpayers, and there's a prompt for you. With all those numbers, you could give someone an estimate of what their liability taxes are going to be if you know all the numbers. Or they could do it themselves. Assume taxpayers are a married couple filing jointly with two personal exemptions, adjusted gross income of $250, modified as $1,125,000. Modified adjusted gross income is when you add back in, you add in the capital gain from the property. That's what gets them from 250 to $1,125,000. They had an original basis of 300,000, capital improvements of 200. They're both alive, married, exclusion of 500. Sell a house for $2 million, cost of sale $125,000. Calculate federal capital gain, net investment income, and state. So figured out the taxable gain on the property. Again, $2 million less original basis plus capital improvements, selling costs. They threw it all in together. Yeah, they put capital improvements on top. Normally, it's an adjustment to basis on the bottom coming up, but it still works out the same. Taxable gain of $875,000. So the long-term capital gains tax on $875,000 is $130,492.50. The net investment income tax, which is Obamacare, was another $33,250. And then the state income tax, $116, because the state income that they jumped into the 12.3 bracket, and there's a 1% surcharge on top of that, so they got hit with 13.3. California, they're at $116,375. Their total tax liability, $280,118. Now again, that's that example there. All right, moving on, withholding. We've talked a little bit about this. You've got federal withholding, typically 15% if you're not a U.S., we'll just say 15% if you're not a U.S. citizen. Now there's a bunch of other green card tests and things like that. When you take a listing, you should have every one of your sellers fill out a withholding affidavit. Unfortunately, the affidavit we use now doesn't list all of the California basis for exemption from withholding. The most common ones for us are the sale was last sold as a principal residence, or the decedent's. It was the decedent's principal residence. Property's being sold a loss, or you're doing a 1031 exchange. That's on the state side. Federal is 15. See here, it's 15% for all non-occupied properties. 10% if it's owner-occupied between $300 and $999. If it's over $1 million, it's 15%. Again, we're talking about people that are non-resident aliens. And if you look at the FERPTA form in your packet, there's a whole explanation of a bunch of different statuses. Your client may have to go to an immigration lawyer maybe to figure out where they are if they're not sure about what their residency status is. This is the form here. It used to be that it used to have all the California was all listed in this form, but now it's not. They took it out. They didn't want us fooling with it. This form has the seller showing their Social Security number. If you don't check, if 4B is checked. So typically under 4A, you're not, the reason this form was created and changed like this is it used to have the seller's Social Security number. Sellers didn't want buyers or anybody else having their Social Security number. So now with 4A, you don't provide the seller's Social Security number. The escrow officer becomes what's called the qualified substitute, and then prepares a qualified substitute affidavit at close, which tells the buyer that I have the necessary Social Security information from the seller to report this sale. Because the buyer's the one who's required to make sure the withholding is done. Okay? But now the way we do it, the buyer doesn't get anything with seller social, and anything that's generated, the affidavits that's generated by the escrow officer does not have the social either. They have it in their records, but it doesn't get disseminated to anybody. Yeah.
So assuming I'm buying a property from a foreign, like H1B guys or something, So the buyer is a citizen or?
Yeah.
So that he's
but
responsible.
He's responsible to make sure that the escrow officer is withholding the money from the seller based on seller's residency status. Doesn't have to do with the buyer's rate status, it has to do with the seller's rate status. The reason this withholding came about was back in the day, when cocaine was just rampant. I mean, it's not rampant now, but when it first became rampant in the late 70s and early 80s, we had cocaine dealers from South America and Mexico coming into Florida and buying houses in Florida like crazy, and then turning around and selling them and paying no capital gains tax. And so then all of a sudden the government said, we're losing out on all kinds of tax dollars because all these non-residents are buying houses and selling them, and they're not paying us taxes. That's why this tax withholding came into being, to try to collect tax money from foreigners that are selling real estate in the United States. Again, we won't spend any more time here. Like I told you, in most cases, we're selling sellers' principal residence. There's no state tax withholding. And if it's a loss or 1031 exchange, there's no 3 1/3 withholding. The one thing that comes up from time to time is if the seller's actual state tax liability is going to be less than 3.33%, then on a 593 form, if they know all the numbers, they can calculate what their actual tax is going to be, which was the example I gave you earlier, from 53 to 12. That was where we had the numbers put down to show that my seller's actual estimated liability was only going to be $12,000. So that's the only amount withheld was 12. But they've got to know the numbers to fill in. So you just have to, the bottom line is, if you've got a seller that is subject to tax withholding, the best thing to do is to have them consult with their tax preparer as soon as possible to determine how they should fill out this form. Because otherwise, what's going to happen is 3 1/3 is going to get sent to Sacramento and sit there, interest-free. And they may not be happy campers when they find out later, oh, we didn't need all that money, we only needed a small portion. Make sense? All right, 1031 exchanges. How many people have done one? Few, okay. Basically, okay, first of all, you gotta make sure you're using the right vocabulary when you talk to clients about 1031 exchanges. It is a tax deferral. It's not tax avoidance. If at some point, see, every time you do an exchange, the basis of the new property, the replacement property, gets reduced by the gain that you deferred. So if you eventually sell the property while you're alive, it's all going to catch up to you. You're going to pay it all. But if you leave it to your kids, it all goes away. Okay? Now remember, we're talking about business or investment property, not personal residence. Now there's no time limit in the code. You can convert a principal residence to an investment property and rent it out. Generally speaking, you should hold it for at least 2 years and rent it for 2 years before you consider selling it to do a 1031 exchange. But in short of 2 years of renting that, you can't use your principal residence. I can't tell you how many times this comes up. It's like they hear a 1031 exchange as a tax-free exchange and they think they can use it on it. No, it does not work on your principal residence. At the time, if it's your principal residence at the time of sale, you can't do a 1031 exchange, period. You have to convert it for at least 2 years before you can utilize a 1031 exchange. And then you can actually, a second home can qualify if you rent it out for at least 14 days annually for at least 2 years and use it for less than 14 days a year. See, remember folks, if you're thinking about let's say maybe you're thinking about buying a second home for your kid in college, or buying a property for your kid in college instead of paying rent, right? You can buy if you don't own any other, you can buy a second home with 20% down and get the normal owner-occupied rate. You can get the better interest rate as a second home. Okay? You don't have to go 25% in non-owner occupied rate, if you weren't aware of that. I'm just segueing as to what the benefits of, why you might consider a second home. It could be for you, but it could be, say, for a child in college. We say like kind. Back in the day, it meant house for house, vacant land for vacant land, commercial building for, no, that doesn't apply anymore. You can do any type of real estate. You can sell anything and buy anything. It doesn't matter what the real estate type is. You can sell a house and buy a commercial property. It just has to be real property. There are other options to real estate. One is called the Delaware Statutory Trust. That's where the trust owns a large asset like an apartment building, and you just own a percentage of that building. And every month you get an automatic deposit in your checking account for whatever the return was on that property. Your percentage of the return, the net return for that month. I had a client that did it. When I first talked to her, she was happy. She was getting about a 5.5% return. She had a condo in San Diego. She didn't want to manage it anymore, about $800,000. She was happy. Then I talked to her a few years later. It wasn't doing as well. So, you really got to do your research on the type of property you're going to invest in to see if the return's going to be, an acceptable return. Charitable remainder trust. Again, that's for uber wealthy people that have so much money they don't know what to do with it. And I just met with a guy the other day that wants to donate a $400,000 condo to a charitable remainder trust, just to take the charitable deduction and then set up an annuity and so forth. Again, some people are very very wealthy; they can consider that. When you're doing when we're doing a delayed exchange, meaning you're not closing on both properties on the same day, when you're selling first and then buying, always consider you've got a Delaware Statutory Trust as a last gap measure if you can't identify a property within the 45 days. So don't let that 45 days expire. Just let them know, hey, we're running into problems. You could, last resort, you could put this in a DST, and at least get the tax benefit of not paying any tax. We've got it's invested somewhere else to qualify. They're not real flexible. You're tied into them a good 6-7 years. There is a way out of them where you could sell them and do something else. But again, it's just something to always keep in mind if you're running into identifications. I had a cousin that, his 25% of Dad's $1.2 million, net sales proceeds was $300,000, and he was going to go to Phoenix and buy a rental house for $300,000, where you could buy a house in Phoenix for $300 all day long. Well, the market was so, and he was all cash. He figured he'd go in there. He was getting beat out left and right, and he was sweating it because the 45 days are, and he finally, like with a few days to spare, he finally identified a couple of them and was able to close on one of them. But that 45 days identification period is a hard stop. There's no extensions.
How do you locate a DST? How do you find one?
Just there's a bunch of different companies that deal in Delaware statutory trusts. Yeah, you just Google it, and there's multiple companies that have owned properties like that. A REIT, a real estate investment trust, does not qualify for 1031 exchange because it's not real estate.
That's my next question.
Delaware statutory trust is.
Thinking of that too.
REITs are not real estate.
There is an UPREIT though, that qualifies.
What's that?
There is an UPREIT that qualifies.
UPREIT?
Yeah.
What's the A stand for?
UPREIT, UP.
Oh, UPREIT.
Yeah, that is, it qualifies for temporary.
Okay, what's the U stand for?
I don't know what the exact meaning of UPREIT is, but there is that specific.
But it's real estate.
Yes, so not the regular REITs.
Right, it's not a regular REIT.
But it is called
It's a
UPREIT.
UPREIT?
Yeah, which
Okay,
qualifies.
I haven't heard of that,
Yeah.
yeah. Now, on tenderloin exchange, the seller and buyer must be the same person or persons, but a single member LLC is okay.
Umbrella partnership, real estate investment.
What's it called?
Umbrella partnership.
Umbrella partnership, okay. Had not heard of that. Learn something new every day. I'll have to add that to my outline. The UPREIT, all right. Again, simultaneous or delayed. Simultaneous means close same day. Delayed means you've got 45 days to identify replacement property and up to 180 days to close on one of the replacement properties. You can have a single. You could be selling as say as an individual or a married couple, and you could create a single member LLC where you're the same people as the sellers, and that's okay on the other end. But otherwise, you've got to have the same buyers and sellers. You can't add people. You can't have sellers, A and B, and then add buyers C and D. You can't do that. It's got to be the same people on both ends. Okay. You need to be buying in order to accomplish it 100%. You need to be buying a property that is equal or greater in value. You'll pay tax on the difference if you don't utilize all of it. Then you're going to pay tax on the difference. But you must at least purchase something, an amount that's equal to the basis in your property. So you can't you can't buy something below whatever your adjusted basis is in the property that you sold. Now, what you apply to the purchase, your purchase price is based on two things. It's based on the net equity, which is the cash coming out of the sale, and the loan amount that's on the property you sold. You have to borrow an equal amount of money as you owed on the property you sold, or more. Now, you can add cash. You can add outside cash and borrow less, but you can't borrow more and take cash out. The cash you take out will be taxed. We call it boot. So again, in order to accomplish it, not avoid, but defer paying any tax, you take all the net equity and the loan amount. So when it comes to, if you're representing a seller/buyer, when you sell a property, you get the settlement statement. It shows you the net cash, and then you look up at the loan amount. What's the loan amount? Add those two together. That's the price. That's the minimum price you've got to pay for the replacement property, and you go up from there. Does that make sense? Can involve more than one property on either side. You can sell two and buy one. You can buy one, sell one and buy two. You can sell one and buy four. You must use an accommodator or exchange company. Approximate cost $850. That's for both sides. I use Starker Services. They're one of the oldest companies that's been around. All your title companies have exchange companies that are affiliated with them. I just have been using Starker for over 25 years. And they're pretty reasonable on their fees too, and they know what they're doing. They've been around. You've got to here's the thing: if you're a listing agent and your seller's going to do a tender exchange, you should be stating that under terms on the listing. And when you negotiate your contract with a buyer, that addendum has to be part of the contract. It's required by the IRS. So if the buyer makes an offer on your property and it doesn't have that addendum, then you have to counter it back and put that addendum in it. Because when you send the contract to the exchange company, they're going to want to see that addendum, because it's required by the IRS. You have one for the buyer, if the buyer's doing an exchange. If you happen to represent your seller as the buyer too, when you write an offer for that seller, you're gonna use the buyer's intent to exchange addendum. That's gonna be required on that deal. Okay? Seller carrybacks, talk to your tax guy, because there can be boot implications there. So you have to identify in 45 days the replacement property. And there are multiple means of identifying. There's 3 different types. One is you can identify 3 properties of any value. And normally I suggest you wait a while before you send in those 3, because 1, 2, or all 3 of those may sell before you have a chance to make an offer. So it just depends on how quick you are. Understand here, what I tell my seller is that, you start looking for replacement properties now, immediately. Start having your eyes on it, depending on how hot the market is. Maybe that property may sit there, may be around. If the market will allow, you could always make a contingent offer, if the seller will allow you, to tie it up, so that you can close it simultaneously or after, even within 45 days, you might be able to do that. That's ideal. My point is, if you give the accommodator 3 properties, they give you a special form, you give them the 3 properties and they all sell, you can keep giving them more properties, up 3 more, and keep doing that. But whatever 3 is in their hot little hand on day 45, that's what you're stuck with. You got to buy one of those 3, assuming you're buying one. There's no extensions. None. Nada. Zip. Okay? And it can be nerve-wracking as those days are clicking by. But remember, DST is a safe harbor, short of paying the tax.
So is it easy to get a contingency offer?
It depends on the market conditions. Right now, I'm sure there's a bunch of sellers right now that would accept a contingent offer, depending upon what you're selling. See, it all goes back to, well, show me what you're selling. And what's the market like for that? How long is that going to take to sell? Markets shift, and so from time to time, you may be able to do a contingency. I mean, I can remember periods of time in my career where sellers would be begging for a contingent offer. Shoot, in April they would have been begging for a contingent offer. Okay? The other rule is called the 200% rule. Any number of you can identify any number of properties as long as the total value does not exceed 200% of the relinquished property. The property is sold. So you take whatever you sold, you take that property times 200, double it, and then you can give them as many properties you want that add up to that 200%. That's an option, alternate one. The other one is called the 95% rule. You can identify more than 3 with a total value exceeding 200%, but you must acquire 95% of the value of all the properties identified. It's a little more complicated than that. Identifying 3 is the simplest, the easiest way to do it. Now you've got it. Now here's the thing. Once you set up the exchange, you close escrow with the accommodator. If your seller changes their mind, the exchange company has to hold that money for 45 days. You can't get it back. So you can't cancel and get it back. And once 45 days passes, this deal falls through, they have to hold your money for 180 days. You can't get it back.
Interest rate.
Yeah, interest free. Yeah. So remember that. So you identified 45, you got to close and replace it with 180. Unless 13C applies, talking about you must close on the earlier of your due date for your return, for the year where the relinquished property was transferred over 100 days. So that means if you have a close of escrow between October 15th and December 31st, you must close by April 15th unless you file an extension. Because it's shorter than 180 days based on that rule. Conversion of principal residence, to qualify for the 255K exclusion, if a property acquired through 1031, you must use it for 2 years and own it for 5 years. In other words, if you have a property that you converted, that you there was an investment property, you want to convert it to, and use the exclusion, you have to show that you've used it for 2 years and owned it for 5. You can't just convert it and sell it in 2 years. You got to wait 5 years. They don't let you take advantage of that. Just 2-year ownership. Reverse exchange. I'm going to be you can buy first and sell first. Basically, your sellers. It's hard to get financing on a reverse exchange, so your seller / buyer is almost going to have all cash to be able to buy the first property, the replacement property first. Any questions? All right, moving on. There's the federal tax brackets we talked about. And you get a lot of people are in the 22%, 96, married 96 to 206, 24% 206 to 394, 32 394 to 501. This is taxable income. That's after taking on, adjusting your income if you had like IRA deductions and things like that, and adjusting for itemized deductions, personal exemptions, and all that things gives you your bottom line taxable income. So that's not, we're not talking about gross income, we're talking about taxable income. And then we saw the state before. This just talks about deductions in general. Now the big thing with the one of the big things with the One Big Beautiful Bill Act, that's what they call it, is the SALT deduction was increased for the next 5 years. The SALT is your state and local income tax deduction. It was capped at under law. Previous law was capped at $10,000. It's now been increased to $500,000 to $40,000 for the next 5 years, which is huge for a lot of people because, I mean, well, you could see from my tax bill. I mean, I'm paying what am I paying in taxes? I even forgot. What am I paying? $9,000? Yeah, I'm paying $9,100. Well, that's almost the whole $10,000. I wasn't able to deduct hardly any of my state income tax on my federal return because the cap was $10,000 for the total of the two. Well, now it's that $10,000 is $40,000, unless my modified adjusted gross income takes me up, over 500,000. Over 500,000, it's going. There's some phase outs of it at that point.
2024 or 2025?
Pardon? 2025, from January 2025 through 2029. A little late for 2024. Well, it's not late. You got till October 15th if you file an extension for 2024. September 15th if you're an S corporation. Yeah. But no, you can't go back and can't go back in 2024. This is just generally speaking, most tax laws that favor the taxpayer go back to January 1st in the year the bill was passed. Most tax laws that don't favor the taxpayer normally don't start till January 1st of the next year. That's generally how some of them go into effect right away. But a lot of them that help the taxpayer roll back to January 1st. And that's what this one does. What else do I want to say about that? The way that works on if you have modified adjusted gross income is like if you have like an IRA, you take an IRA deduction. Well, you add that IRA back into your adjusted gross income, and it increases. If it's above 500, they'll reduce it by 30%, and then it could end up being phased out. When you hit about 600,000, you'll end up back at 10,000. Yeah, when you get up into this higher income, you could end up back at 10. W4, the reason I have this here is that I always, when first-time buyers, when they're pre-approved for a loan, the pre-approval is based on their gross income. Most buyers, when they're told, yeah, you can qualify for this, and this is what the payment's gonna be, and they'll go, oh, I can't afford that, I only take home this much money. Well, if you're gonna buy a house, you can do a new W4, calculate what your deduction's gonna be, and it's even more generous now with the SALT, because if you can estimate what your deductions are gonna be, you know, mortgage interest, state income tax, all your deductions, you can go to your HR or payroll and say, I just completed, I'm buying a house based on my deductions from the house and all the other itemized deductions. It says I'm entitled to this many exemptions, whatever it might be. Most people, single, are probably claiming 0 or 1. They're married, or maybe 2. If they've got a kid or 1 kid, they'll probably get 3. While they buy a house, they may be able to go to 4, 5, or 6 more exemptions. More exemptions means less taxes withheld from their checks, which means they take home more money. So I always tell first-time buyers, you know, and I have to help them. I say, got to figure out, you know, get with your tax preparer and say, hey, can you figure out for me what my total deduction would be if I buy this house at this price with this interest rate on this loan? And they can run all the numbers, say, okay, and then what's my W4 tell me? And then take it to HR payroll and find out that new take-home pay. That might help bridge the gap. Does that make sense? Most loan officers used to talk about this back in the day. They don't even bring it up anymore. They don't want to talk about it. Okay, you're in the real estate business. After you close your first escrow, you are now going to have income and expenses that you're going to have to report on Schedule C. Anyone here has not filed a Schedule C? Okay. What you need to understand is there's a whole bunch of expenses you need to keep track of, all listed there in Part 2. Advertising, car and truck expenses, insurance other than health, E&O insurance, legal and professional services. Professional service can be a tax preparer. Office expenses. I don't know if any of you are paying office rent. Supplies, travel and meals, so forth. I jumped ahead here. Forget that for a second. Itemized deductions. We're in paragraph 8. We're not on Schedule C. We're back on my itemized deductions. What the One Big Beautiful Bill Act did is it made the deduction for mortgage interest on the loan of $750,000. They made it permanent. It wasn't permanent before, but now it's fixed. So we're talking about $750,000 loan limit for a primary residence. So if someone buys a house for $1.5 million and has a $1.2 million loan, they can only deduct the interest on the first $750,000. They can't deduct the whole $1.2 million, the interest on the $1.2 million. It used to be, we used to have $1 million limit and then actually another $100,000 for a second loan. But years back it got that, both those went away and were dropped to $750,000, but it wasn't permanent. Now it's permanent. Now you can, if you have a small loan on your primary, you can have a loan on a second home and combine the two and still deduct up to no more than interest on $750,000 loan amount. The other thing the new bill did is it brought back the deduction for private mortgage insurance, PMI. PMI wasn't deductible, then it was, then they took it out, and now it's back in again. So you get a borrower putting less than 20% down, the private mortgage insurance is now tax deductible. We talked about SALT, talked about withholding. Now we're on Schedule C.
What about a home equity line, is that considered a second mortgage on?
Yeah, that's your second, but again, you've got a 750
Yeah.
total limit. Yeah. So you need to be keeping track of, all of these expenses, because when it comes tax time, you're gonna need to, what you should have is you should get Quicken or some other P&L software and record, record your expenses that way. The one thing that's really a pain to do is keep track of your vehicle expenses.
Yes.
But who here uses Hurdler? Okay, you guys are all missing the boat.
Which one?
What-
Sorry.
Hurdler, Hurdler. When you log into CAR to go open up your zip forms, you scroll down and you're gonna see a link to Hurdler. It is the most awesome app. It automatically tracks every time you get in your car and how far you went. It lets you mark it as business or personal. And at the end of the year, you just push a button, boom, there's all your mileage. There's all your mileage for the whole year. I mentioned it at a tax class last year. You guys looked at me like it was new, and I figured you'd all jump on it.
What is that?
Hurdler, Hurdlr. It's on the Sierra website. It is cool. And it does more. It'll let you track expenses, and you can even take pictures of receipts and it'll log those in. I just use it for the mileage. I just have it on all the time, and I don't have to worry about mileage tracking. Was a pain in the butt. Now there is a rule you can use. Don't freak out. You can keep mileage for 3 months and then multiply it times 4, and that's acceptable. All right? But yeah, go on to CAR, you'll see a link to it, and it's an app. And I think you could probably just go in the app store and find it. But I think we're getting it, I'm trying to think, I think we have it, it's a free service through CAR, if I'm not mistaken. That's why it's on the CAR website. So if you don't do anything else today, start using Hurdler for mileage. Because you have to keep track of your business miles separate from your personal use. And your commute to and from home and office does not count as business miles. Remember, you're supposed to be paying if you expect to have income, you're supposed to pay estimated taxes on April 15th, June 15th, September 15th, and January 15th. If you don't, you're going to be paying some penalties when your tax return's filed. And we also have to pay a self-employment tax, which is 12.4% of the first $176,100 net income for Social Security, and 2.9% of all net income for Medicare. You pay that when you file your tax return as a self-employed person. If you have a TC, now currently for the time being, we're having to pay our TCs direct. That rule may change. We're waiting for that guideline that came out really threw the industry upside down. We're still waiting. Right now, we can't pay our TCs through our commission demands. That may change, but you need to make sure that you issue a 1099 to your TC by January 31. Well, my TCs, I said, don't worry about it. I know how much money you paid me. Well, I said, all right, so I don't. Vehicle expenses. Again, you got to keep track of your business percentage. Use Hurdler. Now, you can go with, you can deduct your vehicle. You can use either actual expenses or the standard mileage rate. Standard mileage rate for 2025 is 70 cents a mile. So this just depends on what you're driving, how much you spend, as to which way. I've been using actual method for years because it always works out. I typically will run, I try not to use my car for personal use to business percentage up. I can typically run around 80%, but if I do a lot of personal stuff, it can sometimes drop to 70, 65, but try to stay around that percentage. Now, if you choose the actual method in the first year, you're locked into it for the next 4 years. You have to stay on actual. You can't bounce back and forth. I just threw in vehicle depreciation here. If you're thinking about buying a car for business, there's a bunch of different depreciation write-offs depending on what you buy. I'm not gonna spend time here. Do know if you're considering an electric vehicle, the tax credit up to $7,500 expires September 30th. So after that, there's not gonna be any tax credit for buying an electric or a plug-in hybrid vehicle. Okay, I bought a plug-in hybrid last year, and so that I got additional tax savings, by taking advantage of that credit.
A quick question. For if you buy a new car, is it?
That's new car. The 7,500 is new car. The
Yeah.
used car is less. It's
It's
a lower
gonna
amount.
be on your company name or?
Well,
if you wanna
no, you don't. If you're a self-employed individual, no, it can be in your name.
Oh, okay.
I have an S corporation, so my S corporation owns my vehicle is registered in my S corp.
Okay.
Once you set up an S corp, everything is in the S corp. My insurance, I have separate insurance, auto insurance, everything is in the corporation. I funnel everything through. And the benefit of the S corp, even before the increase of SALT, what the S corp allowed you to do is allowed this corporation to pay your state income tax. So you got a full write-off of your state income tax. That's one of the benefits of it.
So does it increase the vehicle insurance?
Yeah, I'm paying, because it's a commercial policy.
Yeah.
Yeah, it's a commercial policy. I'm paying about $3,200 for my Lexus, and I probably would have been at about 24, 25. That's with Progressive. I've probably been about 24, 25 through AAA if I was buying it as an individual. So there was a little increase. But I'm getting so many other tax benefits, I don't care about that incremental insurance cost. Because the other tax benefits I got far outweigh that. So that talks about bonus depreciation. Okay, office supplies and office expenses. I just give this to you so you can read it, so you can understand when you're buying stuff, is it a supply or this is all supplies, pretty self-explanatory. Here's all your office things that can deduct as office expense. Guess what, folks? You can write this off as an office supply. The Apple Watch.
Oh, you did it from there?
Okay.
I did it from there.
You write it off as an office. All right? You can read that, and pretty self-explanatory. That's going to tell you about supplies and expenses. All right, go back here. Let's go back to advertising. Advertising. Should be somewhat self-explanatory. I'm not wearing my Keller Williams shirt, but if you buy shirts that are logoed, you can write off the cost of those shirts because it's advertising. If you if you want a closing gift, you go Cutco knives. They're engraved with Keller Williams in your name. You can write that off 100% as an advertising expense, as opposed to a gift expense that's supposed to be limited to $25. Travel and meals. If you're planning a vacation somewhere where there's a Keller Williams Market Center and they may be teaching a class that would interest you that you'd like to attend, plan your vacation around a class being taught in another location that you're flying to. I did that on a trip to Maui. We had an MREA class being taught on Maui, and I scheduled our vacation to coincide with that one-day MREA class. I deducted my airfare. Now, I was in a timeshare, so I didn't have much hotel expense, but if I was in a hotel, I could have deducted 3 nights of hotel and my meals for 3 days. The day before, the day of, and the day after. So think about that. Legitimate deduction. Home office, bottom line is, it's not as much of an audit risk as it used to be, but remember, you have to use the office regularly, and it has to be an exclusive office. Be regularly and exclusively used as an office. I still don't take the deduction, it's just I don't use it exclusively and I don't use it regularly, so I just don't bother with it. Retirement accounts, for 2025, you can contribute up to $70,000 to a SEP IRA, but no more than 25% of your compensation. And you do have what's called a defined benefit plan. You don't have to be incorporated to do a defined benefit plan. Basically, we're talking about a pension plan that can result in bigger contributions and bigger tax savings. But you're tied to it for at least 3 years. What happens is that basically my CPA says if you're making at least $300,000, it pays to have a defined benefit plan. So in 2023, when I grossed $500,000, they set up a schedule for me and showed me how much I had to fund for the next 3 years. The first year minimum was $200, but you could overfund it by another $100. So I overfunded. So I funded it with $300,000, and for that year I saved $100,000 in taxes. Okay, had I only done the SEP IRA at about $65,000, because that was the max. So I saved a huge amount. And for this next year, for 2024, I have to fund it with $200,000, and that $200,000 is going to save me $100,000 in taxes. Now, the only downside is it has to be invested in a conservative account. So you can only get a return of up to about 5%, 4.5%, 5%. But the tax savings far outweighs the return when you lump it. When you look at it, an IRA at 70 versus 200, it still makes sense. Now, on the S Corp side of things, my tax preparer says if you're making over, and now this may have changed with SALT. I'll have to talk to her. It may have with SALT it may have changed, but when the SALT cap was at 10,000, she said if you're making at least $60,000, you should set up an S Corp. But you don't need the S Corp to do the defined benefit plan. So again, just some more food for thought there. So the fun one. And I got a disclaimer up front. I did not know about this when I used my son on these postcards to do that. I did not. No one ever told. I didn't know about it. Okay. How many people have children under 18? All right. Are they cute?
Very.
Are they photogenic? Okay, so you saw some samples there. My son was, 2 of those pictures were just family photos that were cropped, or just one that was just used. One was, he was dressed up for Halloween at Gilroy Gardens, and that was him standing on the bridge, and then one was at Legoland, I think was the other one, and he was just kind of, Lori get the camera out, and he just kind of hammed it up. The other one was a staged photo in Castro Valley called Worthington. Excellent studio if you want first-class photos done of your children. And they have all the props and everything there for all the different holidays. So you've got, here's how it works. The standard deduction for a single individual in 2025 is $15,000. What that means is an individual can make up to $15,000 and pay 0 in taxes. So you can hire your child to work for you, and you can pay them up to $15,000. They will have no income tax. You will write that expense off as a business expense, and the child can turn around with that $15,000 and in 2025 put $7,000 into a Roth IRA that there's no tax write-off, but it accumulates tax-free. And when you withdraw, assuming it's the right age, after 59 and a half, no tax consequences when they withdraw the money. And you can pay your child to be a model, just like I did. The going rate for modeling is anywhere from $25 to $75 an hour. Average US is about $45 an hour. Now it's got to be legitimate. You want to hire, you could hire a photographer if you want to do that, but you could take the time, photographing them, set them up, do like they do in here, and keep track of all that time, and they get paid as a model for doing that.
Can pay them 1099 or have to pay wage?
I'm sorry?
For the, for the children expense, and have to pay them W-2 or 1099?
Okay, you would, you're jumping ahead here. Like if they're under 18, they're not subject to Social Security and Medicare unless you have an S corporation, then you have to withhold. So you do have to use a payroll company. Okay. Basically, for the Roth IRA, you have to pay them W-2. You have to use a payroll company. That's what it says in the first paragraph. Eligible to contribute to Roth IRA, you have to pay your child as an employee through a payroll company.
Then
I
we
use
should have
Gusto. No, you don't need an S corp.
Oh.
The S corp comes in on the Social Security and Medicare.
Oh.
Gusto charges $55 a month for one employee. That's who I use for me. Just so you understand, with my corporation, my gross check goes into my corporate account. I use payroll, and I pay myself 60% of the gross check, and then I have all the taxes and everything come out of that. All right. And actually, for this year, because of the amount of tax and because of the deductions and the law, I'm going to get because of the losses being generated, because of the payroll expense, she's telling me to cap my salary at $250. And when I hit $250, just leave it all the rest in the corporation. Remember, folks, it's an S corporation. The money's all mine. It's all mine and my wife's. So I can pay us a dividend anytime I want and pull it out of there. But the other thing is, remember, the corporation has to pay that pension payment. One other quick thing to understand is, if your corporation's running low on money, you can personally lend your corporation the money at 5%. So there's ways to get around all the different needs that you have, depending on your cash flow and so forth.
So, question, so what do we do if you're not a corporation, then how do you pay your child?
Through Gusto, through a payroll company.
Outside.
You write it, with Gusto, you tell it, pay this person this much money, and you have bank accounts tied to Gusto.
Okay.
And then it automatically pulls so you should have a business account and not a personal. You should have a business checking account, you shouldn't be using your personal checking account. You should have a separate business checking account. And then when you'd have Gusto set up, you'd have that account tied to Gusto. And then you would have a custodial account for your child, another bank account for their receipt of income. So what Gusto does is, you just tell it, pay this person this much money, either on an hourly basis or a salary basis, And it can be, and it doesn't have to be a regular schedule, it can be at any time. And then Gusto will process it all, and then it'll take the money out of your account, and then it'll take their net pay and put it into their account. All right? It does all the work for you. It's real simple. Only takes a couple minutes. Boom, boom, boom. It's all done with those accounts. And it takes care of all the reporting. I don't do anything else. It's all done for me. Reporting it to the IRS, all that stuff's all done. As if I was a payroll department. They handle it all. That's what that $55 a month covers. So you got, that said, the work must be, legitimate, beneficial, fitting, and recognized in the real estate industry, must be appropriate for their age, skills, and the value they bring to the business. Age 7 is kind of generally considered a minimum, but for modeling, it could be any age. You have a baby, baby can sit there, doesn't matter.
So one more question, so for this, the children is just start 2025 or 2000, in the past, they can, for us, we can hire the child, the children.
Well, you can't go back and, it's too late to set anything up now. You can only go forward and do it.
Yeah, but I'm talking about this rule is just apply, start.
Well, this has been around, this has been a tax strategy that's been around for a long time. This isn't something new that just came up. No, you've been able to do this.
I have a question. If the child more than 18 and he has his own income, will it combine?
Well, you can employ your adult child as an employee and pay. They're just going to have different rules at 18.
Mm-hmm.
Yeah, I mean, you can do that. Because if you're not an S corp, see, if they're under 18, you don't have Social Security and Medicare tax to pay. But if they're over 18, you're going to have to run them through payroll, and because you got to take care of those payments.
Last question on that, sorry. So for your kid, if you have an S corp, up to 15,000, you can use it as a business expense.
Yeah, you can write, yeah.
However, when you run the payroll, you have to pay the Social Security and Medicare taxes. If it's an S corp, do you have to pay the Social Security and?
Yeah.
Oh, okay.
Yeah, if you're an S corp, it's in the paragraph 3. If you're an S corp, you have to withhold Social Security and Medicare tax unless you set up what's called a family management company. And I looked into that, and it didn't make sense to do that. But think about it, folks. Imagine, okay, and they can, there's a whole list of things. Stuff envelopes, clean your office, wash the company car, update your customer list, do advanced data entry, transcribe video audio, trips to the post office, general errands, help at the office, pass out handouts, walk door to door, place flyers, update your website, update your social media accounts. They won't even equate that as work. But imagine if you started at whatever age your child is and start putting away, paying them $15,000 and then putting away $7,000 in a Roth IRA. I mean, by the time they're in their 50s, those Roth IRAs are going to be huge. That makes sense? It's not that much money out of pocket. And that money's still sitting in their account. That the money that didn't go in the Roth IRAs is sitting in their account that you can always get to if you need it.
Is there a limit?
Because you're the custodian of the account because they're a minor. See, that's like he was talking about LLC and all. See, under the Uniform Transfer of the Minors Act, a minor can be a shareholder as long as the parent's a custodian of that account, shareholder account, or an LLC account, or a bank account. So you're the custodian. When you go to the bank, you're gonna set up a custodial account for your minor child, be in their name. And as long as you don't pay them more than, this year, more than $15,000, they have no tax liability, period. That's true year after year.
Do they still have to file personally?
Don't even have to file.
No.
But we'll get the benefit.
Well, they get the Roth IRA benefit. They got tax-free income. You get the write-off on get the business expense of that on yours, and they get the Roth IRA that builds up tax-free.
For this subject, I did talk to the CPA. My CPA said it's very, risk to hire your own family, member to do the work. You need a document.
Yeah.
A lot of
Yeah,
documentation.
exactly.
Otherwise, the CPA.
Yeah, I said,
goes special.
make sure you keep track of your child's hours and the tasks they perform. You treat them just like an employee. All it is record keeping. You keep itemized, you put the date, the time in, the time out, you keep track of the hours. You gotta make sure you're paying them a reasonable amount for the work that they're doing. What's minimum wage? You can argue minimum wage for, handing it, going, if your kid's 8, 9 years old and going from door to door handing out flyers. Minimum wage, just like getting a job at McDonald's. They're paying you more.
Can we do it for?
You just can't get, I'm sorry?
Can we do it for 2 kids or only 1?
Oh, every child.
Then it'll be 30,000 businesses.
Each one, yeah, you can, they're an individual person. Yeah, you can be more.
Now you try this one.
But again, you've gotta keep records. It's gotta be a legitimate business use. I wouldn't be worried about it at all, as long as you're keeping good records, showing what they're doing.
But there won't be any official record of doing that, like if I say my son has been out.
You have to keep a record. If you're ever audited, remember, you're filing a tax return showing those as expenses. So you've got to be able to prove that. You've got to be able, you can't make this stuff up. You've got to be able to prove all of that. You've got to show, yeah, my daughter did this on these days and I paid her this much per hour, and that's a reasonable amount for what we did. And that substantiates the deduction.
Is
Yeah.
there any app for these tiny petty expenses?
So what?
Any app for petty expenses?
I got those modeling fees just on ChatGPT. I just asked it, what's the cost?
No,
a
for
child
all
model?
other expenses, if I wanna keep it.
Well, most of these expenses are actual expenses, your
Yeah.
receipts for what
Oh,
you.
that will work, okay.
All of these office, those are your receipts, you keep receipts. You should have, folks, a separate credit card for your business. I have a corporate credit card. So everything that I do that's business is on the corporate credit card. So each month I get an itemized breakdown of all my expenses on the credit card. I mean, I'm like credit card at almost 100%. On my personal American Express card, I have every expense I can pay on a credit card is on that card for the points. I've accumulated massive amounts of points, everything on a credit card, and then I just pay one big bill at the end of the month. But all on a corporate credit card. It makes it much easier for record keeping, much easier at tax time. Do you have a question?
Yes, so for the profit loss, because this is first year and most of it, I mean, as it is right now, it's all loss, you would still keep a record of all of that because there hasn't been any income coming in?
Well, the year's not up. Don't give up yet, the year's not up. No, I would still keep a record of it. Yeah, but but see, you're not gonna have any return to file with no income.
Right.
You're not gonna be required to file a tax return.
Okay.
So it doesn't really matter. Yeah, if you're gonna, for this year, if you have no income, expenses are, because they're business expenses, they're not gonna be deductible on your personal tax return.
So can we do that
They
deduction
have to
next
be on
year?
your Schedule C.
Like if there's
No,
income
you
next
can't
year?
apply expenses from one, no,
Okay.
can't transfer them over.
So I have
Yeah.
a question. So when we are starting off, what is better, like work as an individual or register under LLC or S corp?
Like I said, my CPA said, if you're gonna make over $60,000, she recommended an S corporation for over $60,000. Now, that was when salt was 10,000. Okay?
So when
It's basically, it eliminates the 9.3% self-employment tax that you pay when you file your tax return. But I haven't checked with her since I don't know if this new bill changed that or not. I haven't asked her that question. But yeah, she says over 60,000, it's beneficial to an S corp. There are some fees up front and so forth. But, and on the 5-minute plan, she said 300,000 is the number. You should be at that before you consider the other part of it, that contribution.
Until you earn 60,000, it is better to go as an individual or LLC.
As a what?
Until you have reached that
Well,
point.
you have to do it ahead of time. You have to anticipate what your income is gonna be and then set it up before you make the money. What I would say is, if you know, it's August, if you think, I wouldn't worry about this year. But by December 1st, if you think there's a good likelihood you're gonna make over $60,000 in 2026, then you may wanna consider sitting down, you know, hiring an attorney and having an S corp prepared. I paid, I think it was about $2,800 to set up the S corp.
And between LLC and S corp, which one is better?
Yes.
S-corp is a small
The S corp.
company.
The S
So
corporation.
you don't have more shareholders.
The S corporation, yeah, S corporation is for small, 25 or fewer shareholders. Everything is a pass-through entity. It's not a C corporation, it's a pass-through entity.
So for this thing, we are eligible for Schedule C without, file LLC.
Yeah, Schedule C is for,
You don't have to pay
Schedule C is when you're self-employed.
You don't have to file a tax form, but when you set up corporation, regardless what, $800 per year.
$800, okay.
And then
I
you
said that
set
in the,
up,
in the other
form.
class.
Either you file or you have to hire a professional to file. So the upfront fee is a lot more expensive. And then when you file a corporation, you have to pretty much either you can do documentation or either hire somebody to do documentation for you. So the
It's not that
business
hard.
cost is more expensive than the LLC overall. So this is based on your income level, you have to choose either LLC or corporation.
Yeah, in everything that I've looked at, I think the S corporation is the better way to go because of all the benefits that come from it. Yeah. But again, you gotta be, you gotta have sufficient income to make it. All right?
Thank you.
Sorry for going over a little bit, but I'm going through some of this kind of quickly.
Really helpful, thanks for.
You're welcome. So I want everybody needs to show me the Hurdler app on their phone, running and working within the next week, okay?
But the task only payment, it's like 100 per year.
What's that?
Yeah, I already installed and it asked me, okay, it's only 5 days free and after that I
I
have to
looked
pay
on the car
100.
Is it $100?
100 bucks
Yeah,
bucks
because-
per
Yeah,
year.
well, I'll
Free-
tell you.
It's free on the car website, I just found it.
It's free on the car
I downloaded from the
website,
Play
yeah.
Store, it's asking for the money.
Yeah, on the CAR website,
It's
yeah.
CAR.org, where you
Ah, okay.
Yeah, it's
so-
free on the car website.
just search,
Okay, just from.
just search
Yeah, it's a-
HR,
yeah, it's a,
URLDR, and then it comes up and you can, premium is free on there
Okay, so.
Yeah.
with your membership.
Uninstall this one.
Yeah, I mean, this makes it so easy, because I used to do it manually and it was a pain in the butt.
Yeah, I didn't know, you just saved me $100, cause I was using previously another one I canceled, it was about the same per year, $100 a year.
Yeah, well, Keller Williams came out with another app about 4 or 5 years ago, but it didn't,
Yeah.
it didn't stay in business. Yeah, and then what you can do is if you're, I forget to do it when I go on vacation, I forget to do it, so it's tracking all the travel all over the islands. You can stop, when you know when you start a vacation, you can go in and stop the mileage tracking, and it won't track all your trips on your vacation. Then but then you gotta remember to restart it again when you come back home from vacation.
I forgot my password.
You had a question
It
about
was
the
already-
bank of it, the 1031 exchange, does it not apply to personal residence?
No, it does not. That's what I said in the very
Yeah, beginning, yeah.
not personal residence, unless you convert it to a rental property for 2 years.
2 years. So basically, one of my,
Oh, yeah, it is.
the person who lives at home in the West wanted to do a 1031 exchange. I haven't really checked with him what his property is, but I should have checked with him to find out what he really has in terms of where his property is.